My child being neglected on November
Okay, ma'am,
15th.
stop. We're not taking any more testimony. I've made my
Hey,
ruling,
Dan.
and we're not, and that's it, ma'am. No, ma'am,
She
you
was
cannot say anything.
neglected. She was not paying.
If there's an actual reset order, but there was an order for everyone to appear on today's date. And I believe the state and myself are in agreement with the order. I'm not certain about whether Miss Canaba or Mr. Smith are in agreement with it. I did have a couple of questions about it was reset. If I can remind the court briefly on the status of the hearing and the ruling and all that.
Yeah, this is the one with the drug testing, the positive drug test and all that, correct?
Correct. This court ordered drug testing for Mr. Smith. I paid it. I'm going to submit a voucher to the county, and then for that amount, and then to be reimbursed. And then you had ordered Mr. Smith to reimburse the county in the amount of $299 for that, plus court costs, which the district clerk informed me are $443.
Okay.
For this case.
Okay, well, let's get this officially on the record, and now the party are present, correct?
Both are here. Both are here.
Oh, they're both here. Okay.
Yes.
Okay.
I mean,
I see here. Where she's not in the main room. She's still not.
She has the blue. She has the blue square. Miss.
Oh, okay.
Miss. I don't know what it is. Miss Canaba and Mr. Smith. Are y'all there?
Yes.
Okay.
Yes, sir.
We are here.
All right. Let's get it on the record then. So at this time, we're on Bell County calls number 24 DFAM 349967. In the interest of Canaba minor child, now the party is Dalton Lee Smith. Custodial party is Mia Canaba. Court will take judicial notice of the court file note for the record that both parties have previously been noticed and served. That for the first part of this year, we're operating under a temporary order. And then on the 6th day of October of this year, the court had final hearing in this matter. This matter is before the court today to confirm what that final order should be. My understanding is that it has been prepared and circulated, but it was not signed off on by parties, or was not as far as that was concerned. But anyway, at this time, I'll let the state, this is your case, I'll let you make an opening statement and tell the court what the state's requesting we do here today. The final order that was circulated was that appropriate review, and then I'll let the Atlanta make an opening, and then we'll call the parties as witnesses and take it from there. Thank you.
All right, guys. Buckle up, because right from the start this courtroom shifts from calm to chaos in seconds. A mother steps forward desperate to speak, but the judge cuts her off immediately, shutting down any attempt at testimony. The tension spikes as she tries to explain her child's neglect, only to be silenced again. You can feel the frustration building, the clash between authority and desperation. This is where the emotional fuse is lit, setting the stage for everything that follows.
Thank you, Judge. And state is in agreement with the ad litem and the order that he had circulated previously as he had described it to the court.
All right, thank you. All right, Mr. Smith and Miss Cabana, since you're pro se litigants, represent yourself and not lawyers, I need both of you to raise your right hands while I put you back under oath. Thank you. All right, do you both solemnly swear or affirm the testimony you're going to give this court today is the truth, the whole truth, and nothing but the truth to help you?
Yes, sir.
Yes, sir.
All right, you're both officially under oath, and I'll let the state go ahead. I'll let the Atlanta go ahead and confirm whether or not you're in agreement with the order, and then the court will make a ruling on whether or not the court will just go ahead and assign the order as represented by the Atlanta. So at this time, you may proceed, Mr. Bramhall.
Thank you. So I don't believe I can share.
Don't even share it. If you send it to everybody and they got a copy, just confirm they got their copies and whether or not they're in agreement with it. All right, that's all you need to do, sir. Thank you.
Okay, and I did have two questions for the court about issues related to the order myself. But the order that was circulated, I'll start with Miss Canaba. Can you hear me?
Yes.
Am I saying her name right? Canaba or Canaba?
It doesn't matter. Canaba is the Spanish and Canaba is the English way.
In other words, the inappropriate version of the name. Okay.
Okay.
But anglicized. Okay.
I sent out a copy of this order to both of y'all by email. Did you get a chance to? Well, first off, did you receive the email?
Yes.
Okay, and the order as I've sent it out is 19 pages. Did you have a chance to review that?
Yes.
All right, guys, now watch how quickly the room's energy changes once the judge reinforces his rules. The mother tries again, her voice cracking under pressure, but the judge's patience evaporates. His tone tightens, her frustration grows, and the courtroom becomes a battleground between procedure and pain. You can sense she is not just speaking, she is fighting. This is the moment where boundaries start to blur and control starts slipping away from the bench.
And it addresses all of the rulings from the court that were made at the final hearing on October the 6th. Is that your understanding?
Yes.
Do you have any questions about any of the contents of the order? Or any disagreements with the order?
No, not that I can think of. No.
Okay, so regarding the entry of this order, you're not opposed to it being entered as the final order, is that correct?
I'm not really understanding.
Do you have any legal opposition to this order as it has been presented and drafted?
As in him getting possession to Harper, or?
Okay, here's the man. His question is, I know you're not a lawyer, and that was a lawyer question, but I have a copy of the final order that's been proposed to be entered at this time. Is there a legal reason why the court should not sign off on this order as is, ma'am? That item says he might have something to clarify here in a moment, but as it stands right now, do you have a legal objection to the court signing the order?
Just her being neglected, but other than that, nothing else.
Okay, ma'am, that really not, there's nothing to order about neglect in any of my court orders, so I'm not sure what you're talking about.
I wouldn't like the state to sign it if we don't get this through to y'all, but my answer is no.
All right, thank you. All right, Mr. Grimhall, you may proceed.
And Judge, I just want to make sure that you have the order. There were two versions that were sent out. You have the order that on page 5, it has the possession and access with the definition in parentheses on the second line. Is that right?
All right. Possession and access.
And it should define the Saturdays in parentheses in the second line. Is that the version you have?
Yes, it is.
Okay, good. Okay. All right. So we're looking at the same one. Okay. I will call Mr. Smith. Then, Mr. Smith, can you hear me?
All right, guys, here's where things begin spiraling. The mother won't let go of her plea, and the judge escalates, pushing authority harder than compassion. Voices overlap, and neither side is willing to back down. The courtroom officers start shifting, anticipating trouble. Every second feels heavier as the emotional temperature rises. This is the part where you realize someone's going to snap, and the judge's firm stance is feeding the fire rather than calming the room.
Yes, sir.
All right. And I sent this order to you as well. Did you receive the email?
Yes, sir.
And did you have a chance to review it and take a look at it?
Yes, sir.
Are you are you in agreement or opposed to the court entering this order?
I'm opposed to it for the visitation side.
Okay. And please elaborate your objection.
All right, here's the deal. Wait, stop. Here's the deal, guys. Sir, you can object to anything that was not a court ruling. You cannot object to the ruling of the court as far as visitation is concerned. If you got something that you said is not correct or there's something I didn't rule on, that's fine. But if you're just saying you're not in agreement with it, sir, that's not what that question was about. Thank you.
Okay, so I'll ask a follow-up. So, Mr. Smith, you're opposed to the section on page 5, the possession and access. That's what you're opposed to?
Yes, sir.
Okay. are you opposed to it because you don't agree with the ruling of the court, or are you opposed to it because you believe it does not reflect the accurate ruling of the court?
I'm opposed. I just opposed to the ruling, I guess.
Okay. But given what the ruling of the court was, do you believe the language as contained in these paragraphs reflects that ruling?
Yes.
Okay. All right. So you're opposed to the substance, not the form. Do you understand what I'm saying?
Yes, sir.
Okay. All right. Okay. Anything else in the order that you're opposed to or find objection to?
No, sir.
Okay. Now I have a follow-up question for you specifically regarding court costs on page 14 at the bottom. You were ordered by this court to pay court costs in two specific amounts. Number one is the normal court costs, and the second one is drug testing reimbursement court costs.
Part 4, Original Clip Timeline, 2:15 to 3 o'clock. Alright, guys, watch closely as this is the breaking point. The mother's voice shakes with anger and fear, and the judge responds with strict orders, not sympathy. The officers step in, subtle but ready. The tension is no longer hidden. It's visible, audible, and seconds from exploding. Each exchange becomes sharper, and the courtroom atmosphere turns brittle. You can feel the shift from conflict to confrontation, the moment where control starts slipping out of everyone's hands.
Do you understand that?
Yes, sir.
Okay. And you were supposed to have paid those or had the payment ready by last week on the 30th. Do you have the payment for court costs with you?
I have both the money orders at home. I didn't bring them to work. I forgot. I wake up really early.
Okay, so you're telling the court that you have two money orders, one for $443 and one for $299 ready to send to the court?
Yes, sir. I have the other one as $300 for the change, but yes, sir.
Okay, all right.
Real quick, sir. Real quick. Where do you live, sir?
I live in Cleveland, Texas.
Okay, then. All right, then. I normally like people when they're dealing with money orders, if they live locally, bring it in and then get your receipt directly from the clerk. That way, you know there's no way that can go wrong. Okay. But since you're out of town, you can go ahead and mail it in. But I'll let this. And if you have any questions about that, you can get with the ad item later. You may proceed.
Yes, sir.
Yes, Judge. This is a question I had for the court as well. About this particular section. You had, Mr. Smith logged out of his final hearing and was not present for the rendition of the final ruling. And this court instructed me to talk to him about the ruling specifically about the court cost provisions and the necessity of them being paid and the importance of them being paid and so on. Did the court want me to be the middleman on?
Let's do it that way. Yeah.
Okay.
That way I hate the United. I'm sorry. I do not hate the United States mail. I just don't like sending things, money orders and things like that through the mail because the clerk's office may get it wrong. Some of the mailer may get it wrong. There's too many steps in there. So, sir, I'll have you forward those directly to Mr. Bremhall. He will personally take them next time he's at the courthouse down and deposit them into the registry of the court and send you a receipt for such. All right.
Yes,
Okay.
sir.
Okay, that's what that was my question because I know this court wanted to make sure that those got paid. So
yes, sir.
I can send a prepaid stamped envelope to Mr. Smith, and then he can return the money orders to me in said envelope, and within a day of receiving such, and then I will take the money orders and make sure the court costs are paid for this case using those money orders.
All right, good enough. Thank you. Next question, then, sir. You may proceed with your next question, Mr. Bremhall.
Okay. My final, so Mr. Smith was regarding anything else. So in this order,
Part 5, Original Clip Timeline, 3 to 3:45. Alright, guys, here's where the confrontation fully erupts. The mother pushes back harder, her emotions boiling over, and the judge fires back with stern commands. Officers try containing the situation, but her frustration is too strong. The courtroom is no longer orderly. It's reactive, unpredictable, and on edge. Every voice raised adds another layer of chaos. This is the critical point where the system's rigidity collides directly with a mother's desperation.
In this order, it has your address listed on West Country Road in Cleburne. Is that correct?
Yes, sir.
Okay, it has not changed. And
No,
if
sir.
if I send you a self-addressed stamped envelope to that, you will get it. Is that correct?
Yes, sir.
Okay, is that a PO box like attached to your house, or is that like a mailbox in front of your house, or is it
It's
a PO box?
it's like a PO box, but it's not a PO box. It's a community
Is it-
mailbox up there by the office.
Yeah.
Is it-
Okay.
Okay, is it locked? I guess what I'm asking. You have
Yes,
to
sir.
unlock it?
Yes, sir. It's locked.
Okay. I just want to make sure no one will tamper with the mail. Okay, all right. Okay. Then my only remaining question would be: the court hadn't ordered me released from the case. I'm assuming the court wants me released 30 days from today's date, or 30 days.
30 days from me
Sunday?
signing the order. But 31 days after I sign the order, you're officially released when it becomes final.
Okay, and so I will submit a separate order for that. But yes, okay.
Okay. All right,
So
yes.
Mr. Smith, did you have any other questions about the order that will be submitted?
No, sir. Not about the order, but whenever there's a second at the end, I do have a question.
All right, there's a second at the end, sir. What's your question?
I'm looking into counsel. I'm getting a retainer fee put together. Doing that, I can talk to them about bringing all this back because of the way all this was handled.
Sir, you can talk to any lawyer you wish, and you and your lawyer can strategize anything you think is appropriate, sir. All right, yeah.
Yes, sir. Thank you.
No two lawyers are going to do everything exactly the same, sir. So that's why I got to be real general, because it just depends on who you hire and what y'all figure out what y'all want to try to do. All right.
Okay,
Yes,
Judge.
sir.
Judge, my final question would be for the court. Does the court want to sign the order that it has in front of it, or would you prefer that it get e-filed so you can sign via e-filing?
I'm going to go ahead and sign the one I've got here, and hopefully they won't throw a fit at the clerk's office about it.
Okay.
No, it needs to be e-filed, Mr. Brimhall.
Okay, they're going to throw it. Belinda's polite way of telling me, yeah, the clerk's going to throw a fit.
Okay, I will e-file the order that I circulated and that you have in front of you. I will e-file it as soon as we log off of court today. Did you want it to be circulated for signatures or just submitted?
Just for me.
Okay, I will submit it with no signatures, just for you.
All right, guys, the final stretch is where everything reaches its peak. The judge makes his final decision, the officers move decisively, and the mother's reaction becomes the emotional climax of the entire encounter. Her anger, fear, and helplessness collide all at once. The courtroom's calm facade is shattered. As the officers take action, the judge holds firm, and the room settles only after the fallout. This closing moment leaves you questioning where the line between order and empathy truly lies.
Okay, and I'll note that we had a hearing. I tell you what, do a separate order attaching, that the court granted the motion for entry of order. Okay.
Okay. All right. I'll submit those separate. I'll submit each order separately so that there's a fresh order, final order in the file.
All right. Good enough. Thank you. All right, everybody. Thank y'all all very much. Everybody have a good New Year and a Merry Christmas, and take care, folks. And I'm going to may the parties be excused at this point then, Mr. Brimhall and Mr. Gwynn.
I believe so. Mr. Smith, I'll be in touch with you by physical mail and by email.
I have a question.
Yes, ma'am. What's your question?
Are we getting released from court? Like it's final and things are being signed?
Yes, ma'am. This is the final order. That's what that means. And what that means, I'm going to sign an order as the final order of this court, and under Texas law, you lose the right to appeal that 30 days after I sign it. So it's got 30. That's 30 days. It's still out there for y'all to file anything that y'all think's appropriate.
May I say something if we're going to be released off of court?
Okay, now what do you want? If it's what's it about? What is the subject of what you want to say, ma'am?
my child being neglected on November
Okay, ma'am,
15th.
stop. We're not taking any more testimony. I've made my
Hey,
ruling,
Dan.
and we're not, and that's it, ma'am. No, ma'am,
She
you
was
cannot say that.
neglected. She was not changed.
Ma'am.
Oh, wow. Okay.
Here's the deal. Here's the deal, ma'am. This is my court. We've passed all that. All testimony has closed. All right. This was an order this was a hearing to enter order, and I granted the entry of the order, ma'am.
All right. So it's okay for my child to be neglected. Thank you.
Ma'am, if you say one more word like that, I'm going to fine you. You understand me? I don't play games like this, ma'am. You want to play with me? I can play tough. You can end up in Bell County for a few days if you don't mind, if you want me to go that route. Understood? Do you understand me, ma'am?
Yes, sir.
All right. This present the order, Mr. Brimhall, and we're off the record. Thank you.
Thank you.
Are we free to go, Your Honor?
Yeah.
Free to go. And I'll sign the order as soon as Mr. Brimhall sends it over. Thank you.
Yes, sir. Thank you.
Okay. I'll make sure both of you will get a copy by e-filing and email as well. Okay. Oh, he's gone. Here he left. All right.